Hi there, Andrew Reed here with part 2 of my study guide for the upcoming NCA exam in 2023. And we're going to go ahead and move into the second part here, part 2. So this is just following along the syllabus, and I'm doing case briefs and notes on the hyperlinks within. So in this case, in part 2, we're talking about the primacy of the Constitution of Canada is the first hyperlink there under judicial review. And it says basically 3 parts to this. Constitution of Canada is the supreme law of Canada. Any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Underline, to the extent of the inconsistency. And the Constitution includes the Canada Act of 1982, the acts and orders referred to in the schedule, and any amendment to any act. Okay. Amendments to the Constitution of Canada shall only be made in accordance with the authority contained in the Constitution of Canada. So that particular passage of the Constitution was noted in the hyperlink. Next, moving into my case briefs of R.V. Morgenthaler, the abortion case. In this sense, the main issue here was whether the acts creating prison sentences for abortions outside hospitals were ultra vires, on the ground that they are in pith and substance criminal law. And the conclusion they came to is that, yes, these acts were in their pith and substance criminal law, as such, beyond the jurisdiction of a province and of Nova Scotia, and it had to be struck down. So some of the rules that I found here were classification of a law for purposes of federalism involve first identifying the matter of the law, then assigning it to one of the classes of subjects, as outlined in subsections 91 and 92 of the Constitution Act of 1867. So those are the heads of powers. Province has powers. Federal government has powers. They are listed and enumerated there. So a law's matter is its true character, or the pith and substance. So typically all laws start with that under judicial review, under that pith and substance analysis. So first they're looking at the legislation itself in order to determine the legal effect. Then they're going to look beyond the legislation, find out the background, context, purpose, and they can consider evidence of the practical effect of the legislation, although it's not always relevant, and you don't necessarily need proof of that long-term practical effect to establish the true character of the legislation. So their analysis here as to how they came to this conclusion that this act was criminal law in pith and substance. So they're saying since these laws deal with the subject historically considered to be part of the criminal law, the prohibition of the performance of abortions with penal consequences, that they are suspect on their face, not necessary to invoke the colorability doctrine, which I will delve into in a second. And examination of their terms and legal effects, history, purpose, circumstances surrounding their enactment led them to the conclusion that the central purpose and dominant characteristic is restriction of abortion because it's socially undesirable, and therefore should be suppressed or punished. And it's not necessarily to find out what the actual impact of this is, according to them. They say that they don't have to prove that it's going to restrict access to abortions. They're just saying that the legislation has an effect on abortions in private clinics that's indistinguishable from the provisions of the criminal code. And those provisions had been eliminated. So this overlap of legal effects is capable of supporting the inference and the conclusion that the legislation was designed to serve a criminal law purpose. So ultra vires, can't do it, struck down. Here are some notes that I've made. Some of these are from supplements that relate to this case. Just these little quotes, basically, can be used for analysis purposes, or at least that's what I will personally use them for. So Justice Major in the R.J.R. McDonald case said that prohibited activity, in order to be considered criminal law, must pose a significant, grave, and serious risk of harm to public health, morality, safety, or security before it can fall within the purview of criminal law power. But Justice Arbord agreed 2003, so that is more recent. He says there is no constitutional threshold of harm required for legislative action under the criminal law power. That was in the Malmo-Levine case. So there's definitely some disagreement there, which makes this ripe for NCA exam question. Okay, they also mentioned the doctrine of colorability. And so what I found here, courts will strike down colorable statutes, federal legislation which tries to disguise regulatory purposes lying within provincial jurisdiction by casting the statute as a prohibition enforced by criminal sanction for breach. And the source I found for this reference Section 5A of the Dairy Industry Act in 1949. Okay, next case under judicial review here is Canadian Western Bank versus Alberta. And the issue was whether banks, as federally regulated financial institutions, must comply with the provincial laws regulating the promotion and sale of insurance. So Alberta had laws regulating insurance sales. Canadian Western Bank said, well, we shouldn't have to follow those because banking is a federal power. But insurance is a provincial head of power. And the courts here said, yes, banks have to comply with the provincial laws. Some of the rules I found within this case, regulation of insurance has been generally held to be a matter of provincial jurisdiction under Section 9213 of the Constitution Act of 1867. The fact that a matter may be for one purpose and in one aspect fall within federal does not mean it cannot, for another purpose and another aspect, fall within provincial. That's Hodge versus the Queen, supported by Bell Canada in 1988. And then a court should favor, where possible, the ordinary operation of statutes enacted by both levels of government. In the absence of conflicting enactments of the other level of government, the court should avoid blocking the application of measures which are taken to be enacted in furtherance of the public interest, which is from the General Motors case. So some of their analysis here, based on these rules and others, the fact that Parliament allows a bank to enter into a provincially regulated line of business through the Bank Act is what they're referring to, such as insurance, by federal statute, does not mean that this all goes under the banking, or all under, the banking head of power in 1867. So it's okay to create a statute that expands their powers, but it doesn't expand the Constitution head of power itself. So when promoting insurance, provincial power, the banks are participating in the business of insurance. And in that way, the banks can and will have to comply with both federal and provincial laws, and which they do in many cases otherwise. When federally regulated entities like banks take part in provincially regulated activities like insurance, there will be a jurisdictional overlap, and that's okay. So there's no paramountcy doctrine engaged here because there's no conflict with a valid federal law. So it's okay. No paramountcy doctrine, law still valid, legislation will apply. And there's no operational conflict because compliance by the bank with the provincial insurance laws will complement and not frustrate the federal purpose. So it's okay here. Some notes I made here on some of these doctrines, and just to make sure that I'm aware of what they are, that so in certain circumstances the powers of one level of government must be protected against intrusions, even incidental ones, by the other level. That's why they're enumerated in the Constitution, so that they would be generally separate, although there's arguments through the courts over the years on this. So, to make this happen, the courts have developed two doctrines. First, doctrine of interjurisdictional immunity recognizes that the Constitution is based on allocation of exclusive powers to both levels of government, not concurrent powers, and although these powers are bound to interact in the realities of life in our Constitution, so it's exclusive, not concurrent. That's interjurisdictional immunity. Keep them separate. Keep them in watertight compartments, to quote one clever judge that I read about. The second, the doctrine of federal paramountcy, recognize when these federal and provincial laws come into conflict, the federal law prevails. Yeah, that's just the way it is. but again, have to come into conflict. The double aspect doctrine, which was referred to in this case, applies to the court in the course of a pith and substance analysis. And it just ensures that the policies of the legislators of both levels of governments are respected. You can have these two. Interesting note from the Irwin Toy case, that nice little quote for analysis: in the absence of impairment, interjurisdictional immunity does not apply. So concludes part 2 of this constitutional law study guide for 2023. Please, guys, give me a like, comment, subscribe. So much appreciated. Helps justify my time in making these. And wish you all the best of luck on your next exam.